Welcome to the Deep Dive. Our mission today, we're cracking open a contract concept that honestly trips up a lot of people. The condition precedent. We're looking at that classic situation. One side says, hey, you owe me money, you breached the contract. Pretty straightforward claim, right? But then the other side comes back with something like, hold on. Yeah, maybe, but you missed a step. You failed a basic procedural thing we put in the contract. And suddenly the argument isn't about the money anymore. It's your whole case is invalid because you didn't jump through this hoop first. So we need to figure out, when are these hoops, these conditions, actually enforceable? When does a court say, nope, that's unfair? And crucially, what happens if you just miss it? What's the fallout? Our guidepost for this is a really interesting case from the Alaska Supreme Court back in '62. Inman v. Clyde Drilling Company. It shows just how much power a simple 30-day notice clause can have.
Exactly. And we're going to use Inman to really model how you'd break this down legally, element by element. So first, we'll define what makes these conditions stick, especially when someone argues they're unfair or against public policy. Then we'll dig into why simply filing a lawsuit, like Inman did, often doesn't count as meeting the condition, even if it gives notice. And finally, the really critical part, the procedural consequences. We'll spell out the huge difference between a claim being put on hold temporarily versus being completely wiped out, permanently barred.
Okay, let's dive in. So as a general rule, when two parties who seem competent sign a contract with these kinds of procedural steps, how strongly do courts enforce them? And when do judges actually step in and say, no, this isn't right?
Well, the starting point, the absolute bedrock here, is freedom of contract. The general rule is simple. If you're a competent adult, you can agree to pretty much whatever terms you want, and the courts expect you to stick to that deal. The court's policy isn't to second-guess your choices, it's actually to maintain and enforce contracts. They want people to be able to manage their own affairs. It's not their job to rewrite your agreement just because you regret it later.
Okay, that sounds logical, but, we all know contracts aren't always negotiated between equals. Like in Inman, you've got an employee, Roy Inman, versus a drilling company. There's a power imbalance there, surely.
Yeah.
When does that imbalance become so bad that a court has to intervene?
Right, and that's where the public policy exception comes in. But, and this is important, the bar is set incredibly high. Courts are really reluctant to tear up a contract. They'll only refuse to enforce a specific term if there's a clearly revealed public policy against it. We're not talking about just general unfairness. The court needs solid proof. They have to look realistically at the relative bargaining positions, like you said, and find clear evidence that one side, quote, unconscionably took advantage of the necessities and distress of the other. That's famous language from Justice Frankfurter. So you need clear facts showing real exploitation, not just, speculation that the deal wasn't perfect.
Got it. A very high bar indeed. So let's put Inman v. Clyde Drilling Co. under the microscope using that standard. Why didn't the court step in for Mr. Inman? Let's analyze Inman v. Clyde Drilling Co. First, what are the legally dispositive facts? What actually happened with Inman and this contract clause?
Okay, so Inman worked as a derrickman for Clyde Hall. He had a written employment contract. Now, that contract had this specific clause. It said any claim he wanted to make against the company had to be submitted in writing within exactly 30 days after the claim arose. And crucially, the contract stated that doing this, giving that written notice, shall be a condition precedent to any recovery. Inman got terminated on March 24, 1960. He then filed a lawsuit and served the company with the complaint on April 5th, so well inside that 30-day window. But here's the key. He never sent that separate formal written notice the contract demanded. And, importantly, he admitted later that he had read the contract and even discussed its terms before signing it.
Okay. And what was the core legal issue the court had to grapple with regarding that specific notice condition?
The precise question was this. Is that contract clause the one making written notice within 30 days a condition precedent void? Is it unenforceable because it's against public policy, maybe due to being fundamentally unfair, or because of that potential inequality in bargaining power?
Got it. So what rule of law did the court use to decide if it should step in and void that clause? Lay out the full rule for voiding on public policy grounds and break down its testable elements for us.
Right. The rule the court applied has essentially 3 parts, 3 elements that all need to be met based on clear evidence of unconscionability. So first, one party must have unconscionably taken advantage of the other's needs and distress. Exploitation, basically. Second, there had to be a substantial inequality in their bargaining positions, enough to suggest that one party, like Inman perhaps, didn't really have any real freedom to choose or negotiate that term. And third, the reasons for the court stepping in have to be based on clear, concrete facts showing a violation of public policy, not just guesswork or a general feeling of unfairness.
Perfect. Okay, now for the court's elemental analysis. Let's take it step by step. How did the court apply that first element, the unconscionably taking advantage part? Did they see an unfair motive?
No, they didn't. The court looked at the purpose behind the 30-day notice clause. They reasoned it likely wasn't meant to cheat employees. Instead, it probably served legitimate business needs. Things like allowing the company to investigate claims promptly while evidence is fresh, maybe try to resolve things early, and also preventing stale claims from popping up months or years later. Because they saw a reasonable business justification, they concluded there wasn't evidence of an unfair motive to bilk employees out of wages. Element 1 wasn't met.
Understood. Okay, now, what about the second element, the substantial inequality in bargaining positions? This feels like it should have been Inman's strongest point, right? Employee versus company.
You'd think so, but the specific facts presented in court actually worked against him here. The evidence showed it wasn't quite a take-it-or-leave-it situation pushed on him at the last minute. Remember, he himself attached a copy of the contract to his lawsuit, showing he had it and knew it. And crucially, he admitted under oath that he had not only read it, but had actually discussed the notice requirement with a company rep before signing. So the court felt this undercut the argument that the terms were imposed without any real freedom of choice. His own actions suggested he understood and, to some extent, accepted the term. Element 2 also wasn't met based on his specific facts.
Wow. Okay, so after finding neither of those first two elements were met, what was the court's final conclusion on the public policy challenge overall?
Well, given that they couldn't find clear evidence of unconscionable advantage or substantial inequality under these specific circumstances, the court concluded they weren't justified in refusing to enforce the deal Inman signed. The general policy favoring freedom of contract won out because Inman's situation didn't meet that high bar for judicial intervention. So the condition precedent stood. It was valid.
Okay, this is where it gets, I think, even more critical from a practical standpoint. We've established the clause is fair enough to be enforceable. But Inman did notify the company by serving them with a lawsuit within the 30 days. That complaint laid out his entire claim. The company definitely had actual knowledge. So why wasn't that good enough? Why did the court reject this as substantial compliance? Isn't that just elevating form over substance, potentially letting a technicality kill a real claim?
That's a really common reaction, and it feels counterintuitive, doesn't it? But the court was laser-focused on the exact words of the contract. The rule they applied is pretty strict. When the contract explicitly spells out a specific method for fulfilling a condition precedent, courts generally enforce that exact method. The contract didn't just say, let us know, it said, give written notice. And arguably, the purpose wasn't just knowledge, but knowledge delivered in a way that triggered an internal process before any lawsuit started. Plus, and this was also key, the contract had that other clause requiring a 6-month waiting period after giving the written notice, but before filing suit. By suing immediately on April 5th, Inman didn't just use the wrong form of notice, he directly violated that mandatory cooling-off period. So it wasn't just substantial compliance versus strict compliance. His actions actively contradicted another part of the condition precedent process.
Ah, I see. So it wasn't just what he told them, but how and when. Filing the lawsuit immediately jumped the gun on that 6-month delay period specified in the contract itself. Okay, let's shift to the procedural tactics. Inman tried another angle. He argued, look, even if I messed up the notice, the company didn't raise this failure in their initial response to my lawsuit. End quote. Normally, failing to give notice might be seen as an affirmative defense, something the defendant has to plead specifically, like under Rule 8c, or they waive it. Inman claimed they waived it. Why did that argument work?
This is probably the most important takeaway from Inman for anyone drafting or analyzing contracts. It's all about how that clause was labeled. You're right. Ordinarily, failure to give a required notice is treated as an affirmative defense. The defendant carries the burden to raise it. If they don't, tough luck for them. However, because this contract explicitly labeled compliance with the notice provision as a condition precedent to any recovery, that label completely flipped the script procedurally. By definition, fulfilling a condition precedent is part of the plaintiff's basic case. It's something the plaintiff has to do before the defendant's obligation even arises. Therefore, the burden was on Inman, the plaintiff, to plead and prove that he had performed the condition, or show why he didn't have to, like waiver or excuse. Since he couldn't plead performance, his claim was fundamentally flawed from the get-go. The company didn't need to raise it as an affirmative defense because it was Inman's hurdle to clear first.
Wow. That's incredibly powerful. Just using the magic words condition precedent shifts the fundamental burden of proof onto the claimant from the very start. The company didn't even have to point out the failure initially.
It's a huge drafting advantage, yes.
Okay, so let's get to the bottom line, the final outcome. The trial court found Inman didn't meet the condition. Inman argued, okay, fine, dismiss my case without prejudice. Let me try again later, maybe. That's called abatement. But the court didn't do that. It affirmed a final judgment against him, meaning his claim was dead forever. Why did failing this condition lead to a permanent, fatal bar, not just a temporary setback?
Right, and this hinges entirely on timing and possibility. Abatement dismissal without prejudice is the remedy when the plaintiff has failed a condition but could still potentially fulfill it. Think of it like a temporary roadblock. So if the contract said, get an appraisal before suing, and you sued first, the court might abate. You go get the appraisal, then you refile. Performance is still possible. But here's the kicker in Inman. The condition wasn't just give written notice. It was give written notice within 30 days after the claim arises. By the time the courts were ruling on this, that 30-day window had slammed shut, long gone. Performance of the condition giving notice within that specific time frame was now literally impossible. He couldn't turn back time. Since the condition could never be met, his right to sue based on that contract was extinguished permanently. No second chances. That's why it resulted in a final bar.
Okay, let's nail this down with a quick hypothetical. Let's make it slightly absurd. Imagine the contract said Inman had to give written notice within 30 days and wear a silly hat while delivering it. Okay. Now, suppose Inman filed his lawsuit on day 10 without the notice and without the hat. The company files a motion to dismiss. The judge rules on day 25, so before the 30-day limit is up. What happens then? Abatement or bar?
Ah, good one. In that scenario, because the 30-day time limit hasn't expired yet when the judge rules, it would almost certainly be abatement. Dismissal without prejudice. The judge would say, look, you messed up. You didn't give the notice, you didn't wear the hat, and you skipped the waiting period by suing early. But crucially, Inman could still potentially comply. He could theoretically withdraw the suit, put on the silly hat, deliver the proper written notice before day 30 hits, wait the required 6 months, and then refile his lawsuit correctly. Performance, however silly, is still possible within the contract's time limit. But because in the real Inman case, that 30-day clock had run out by the time things got sorted, the hat, the notice, everything became impossible. Game over. Permanent bar. It's all about whether performance is still feasible when the issue is decided.
That really clarifies it. The time limit makes all the difference between a temporary stumble and a fatal fall. This whole deep dive just underscores how a seemingly minor procedural clause, that 30-day notice, can completely obliterate what might otherwise be a perfectly valid claim for money owed. Freedom of contract cuts both ways, huh?
It absolutely does, and it means you have to read the fine print. So to wrap this up, if you're analyzing a contract dispute involving conditions, especially maybe for an exam or advising a client, here's a kind of diagnostic checklist based on what we learned from Inman. 1. Identify the condition. Does the contract clearly, explicitly label something as a condition precedent to any recovery or similar magic words? That label's critical. 2. Public policy check. Are there concrete facts showing extreme unfairness, like unconscionable advantage being taken and substantial inequality in bargaining power? Remember, courts are very hesitant here. Don't just assume inequality is enough. 3. Pleading burden. If it is a condition precedent, remember the burden flips. The plaintiff, the claimant, has to plead and prove they met it. It's part of their initial case. 4. Compliance. Did the claimant follow the exact procedure laid out, or did they try a shortcut, like just filing suit and claiming actual knowledge? If the contract specifies the method, like written notice, specific timing, strict compliance is usually required. And 5, the bottom line, effective non-compliance. Look at the timing. Has the deadline for meeting the condition passed? If yes, and performance is impossible, it's likely a permanent bar. Final judgment. If performance is still possible, it might just be abatement. Dismissal without prejudice.
That's a fantastic practical checklist. This look at Inman really drives home that getting the procedure right isn't just tidying up. Sometimes it is the whole ballgame. Now, here's a final thought. The Inman court back in 1962 hinted that if these kinds of tight notice clauses became tools for widespread abuse by employers, maybe the legislature would need to step in. That was over 60 years ago. So think about this. What laws have been passed since then? Are there modern statutes, maybe in employment law specifically, or even in areas like insurance contracts that now override these strict short notice periods? Do current laws sometimes say actual knowledge is enough? Regardless of what the contract says, that's something for you to maybe look into or just mull over.